Good afternoon and welcome to another session of the Advice Media webinars. I'm Chad Erickson and glad to be able to be your host again today. These webinars have become very, very popular, and we appreciate your attendance and hope that you continue to find the information very valuable and helpful for your practice. Today we've got a good friend of mine and a wonderful guest who will be presenting. Before I introduce Mike Sacopulos, let me first of all just make note of a couple of things. On the GoToWebinar control panel on the right side of your screen, you'll see an area for questions. And I hope you'll use this. We've got Mike here, and Mike is really here to take a lot of your questions. He's going to go through a few items that are really important today that have come up recently and speak about those, and then really open up to a question and answer where you get an opportunity to really ask the expert on medical risk issues, which all offices are faced with. When we think about medical law and particularly with HIPAA law here in the United States. So please take time to put down your questions, and we'll do our best to get to all of those today, and I will take care of moderating those. But let me go ahead and introduce our guest today. Michael Sacopulos, he's the CEO of Medical Risk Institute. Medical Risk Institute provides proactive counsel to the healthcare community to identify where liability risks originate and to reduce or remove these risks. Michael won the 2012 Edward B. Stevens Article of the Year Award for MGMA. He's written for Wall Street Journal, Forbes, Bloomberg, and many other publications for the medical profession. He's a frequent national speaker, and that's actually where I met Mike, was on the speaking circuit at where we're both faculty on a couple of different, or for several different groups, and had opportunity to get to know each other through that. Mike attended Harvard College, the London School of Economics, and Indiana University, and Purdue University School of Law. And we'll make sure you've also got Mike's contact information. So if you do have questions, things that Mike can help with, he truly is the expert on this, and he and his team look forward to being able to help you privately as needed as well. But Mike, welcome. It's always a pleasure. And for those of you who don't know, I mean, when it comes to this session, when Mike speaks, you know, mine's like the boring one. Everybody is like, I'm not even the setup guy. I mean, after me, nobody wants to talk to me. You know, everyone wants to talk to Mike. You know, it's the best Q&A session, and I sit there fascinated, and I don't even own a practice. So, Mike, thank you so much for taking time to be here today, and appreciate your efforts.
Well, Chad, it's my absolute pleasure, and thanks to you and Advice Media for this opportunity. I'm looking forward to discussing some issues that come up in cyberspace for practices, and I'm just going to jump right in. I would encourage any of your attendees, if they have questions, to type them in their box, and I will be thrilled to attempt to answer them. All right, so here we go. Let's start right in with your practice's website, and how in the world can a website actually cause you legal concerns or trouble? Well, sadly, there are a number of different ways. That's the bad news. The good news is they're really pretty easy to avoid once you know. So this is more of an awareness type of problem, and you are about to become aware of issues related to photographs. Look, there are companies out there that are searching to see if you are using one of their photographs. Getty Images is one, and they have the rights to all kinds of images, and sometimes people accidentally or maybe even on purpose misappropriate an image, put it on their website because it just looks so beautiful, and then they get a claim from Getty Images. Look, there are plenty of ways to properly get rights to photographs. They're not that expensive. Do it correctly up front. Otherwise, you'll be like one of my clients that got a note and had to pay several $1,000s for infringement. So, word of the wise, it's best just to make sure you have the rights to all images that are appearing on your website. Easy to do. Get it taken care of up front. Now, for those of you that are using before and after photographs of patients in the aesthetic world, this is very popular. You want to make sure that you have the patient's consent, and that seems relatively obvious to many of you, I'm sure, but it doesn't always happen. The other problem is sometimes the consents aren't exactly what they should be. Look, if it is a consent for medical photographs, right, which is what before and afters are, the patient must have the ability to remove their consent at a later date, and that needs to be written into the consent. A little bit different if you're just taking photographs at a party and it's not a medical photograph, but it's a group setting. There they do not have to have the ability to withdraw consent. So make sure that that little twist is in your written consent policy that you have patients sign. And then I'll briefly talk about one little problem that we're seeing more and more of, and that is people doing what is called scraping, or taking images off of one website without permission and using them on their own. And we've seen this in before and after photographs. I know a number of surgeons that their results have been seen on as many as a dozen or more different websites around the country. Somebody's just basically stolen their images and posted it as though they have done that work. So I'm asked oftentimes, well, how do we patrol for this or police for this? How do we find out if somebody's really taking our images? And you can, there are several services if you look at reverse image searches on the web that are free, and you can put your own images in and see if they appear anywhere else. This is not something that is costly or terribly time consuming. I don't think that you have to do it on a monthly basis, but every once in a while I think it's worth checking and seeing if anyone has taken images from your website, because you would certainly have legal recourse if they had. All right, onward to the Contact Us page. This is a page we all want, right? We want folks to reach out to us, and this is the start, hopefully, of a relationship. All good here. There's nothing wrong with having a Contact Us page as long as we have some appropriate disclosures. In the medical world, we need to know that communication is secure. This comes to us from the HITECH Act. And if your communication is going through the web page, oftentimes it is secure. Sometimes the pages are set up this way and it really is effectively like you receive an email, and it is unencrypted. A little note to the patient that communication is unencrypted. You'll see at the bottom that we have comments, and this is a potential liability and nightmare for folks because patients can post all kinds of things in there, and if you're not reading them, that later on it can be claimed, well, look, we sent the information to the practice and they just didn't respond, and I've had some kind of medical problem as a result. So I think what you need to do is to have a couple of different posts associated with the Contact Us page. One of them is the very thing that you have on your answering service after hours, right? If it's an emergency, don't send us a message on our website. Call 911 if it's a true emergency. Sad that you have to tell people this, but certainly if you're telling them this on the phone recording, you need to tell them on the website as well. We also want to say that it doesn't create a physician-patient relationship when they send this medical information on over, right? Because you don't want to be on the hook for any random person that puts in information. And by the way, you may legally not be able to if they're outside a state that you are licensed in. So again, we're really just talking about some disclosures, and you can either have them on that page, which I think is the most effective, little note at the bottom, or some practices use a terms of use page on their website that is specifically geared towards medical practices and has issues that relate to medicine, as opposed to just a terms of use that could be the same if you were an electrician or a used car sales site. So make sure it applies for what you're actually doing. All right. I fully realize that I'm humping through this material. So, ladies and gentlemen, if you have questions, feel free to put them on, and we will get to it. Many people don't realize that your website, under the law, is considered a piece of real estate, which means that the Americans with Disability Act applies to your website. All federal websites have been compliant with the Americans with Disability Act for well over a decade. This is not new technology. This is not new law. all of which should tell you that there's not much place to hide if you get a complaint and your site's not compliant with ADA. So what does that mean? What are we talking about, disabilities and website? Well, for those folks that have low vision or have visual disabilities, that means that they move the cursor across the screen and text will be read. And there's usually programs that they have that will do that, but you want to make sure that you're compatible with these kind of programs. For those folks out there that have hearing problems, if there's an audio component to your site, that the audio is closed caption for those folks. And that's really where we are with Americans with Disability and websites. And you're thinking, okay, well, I've never heard of this, and what could possibly be any kind of exposure on something like this? Well, I need point you no further than the retailer Target, who recently settled a class action lawsuit with the National Federation for the Blind for in excess of $6 million for this very issue. A number of big names, household name entities have settled lawsuits on this very topic of having websites that were not compliant with the Americans with Disability Act. Again, it's not a terrible, difficult standard, and your web folks should be able to help you with it. All right, onward. Now, here we have Section 1557, and this is a new twist in the law. This just came online in the middle of October, so just a few weeks ago. And I have to tell you that when I first heard of this, I really thought that it might be somebody might be pulling my leg. Here's what it is. It talks about non-discrimination, and we can all buy into that, right? That medical practices should not discriminate against patients, different types of patients, whether it's sexual orientation, ethnicity, you name it, no discrimination. Okay, fair enough. What does this have to do with your website? Well, there's certain notices that you have to post about non-discrimination. They have to be in your office, but that's outside of the scope of what we're talking about today, since we're talking about the virtual world. So there are notices that need to be posted on your website. Okay, fair enough. You can get a sample notice and put it up. But here's the part that is really the twist on this that I didn't believe when I first heard it, and that is that a disability is considered folks that have limited knowledge of English, that have limited proficiency in the English language, and for those people, you have to provide an interpreter at your cost, at the cost of the practice. Okay. And you have to post notices that you will do so on your website in 15 different languages. And I can hear you say now, people shaking their head, wanting to attack the lawyer, all of which I fully understand. My wife's in private practice, and I got this full tilt at home when I told her. But yes, and the 15 languages have been selected by the federal government for your state, the 15 most common languages used in your state. So I'm in Indiana, and the 15 languages for Indiana might not match up the 15 for New York. There are probably some overlap. We can imagine that Spanish is on everybody's list, but there are others that switch. So you need to check. This is something that you can check on the Office of Civil Rights website. They're part of the Department of Health and Human Services, and they have the list and they have the notices, so you can be able to take these things and get them up onto your website. Now, this is relatively new, so we haven't seen a lot of enforcement action, but the very, very scary part to me is the law allows for what is referred to as a private right of action. That means that it can be enforced by somebody other than the government, meaning an individual out there can file a lawsuit against you if your website does not comply with this Section 1557. So I would put it on the list of things to get to relatively quickly, because we don't want people out there trolling for litigation, looking at website after website to find somebody that doesn't have this, and then launch a claim. Okay, so word to the wise: just be careful on that. Section 1557. I think you'll find what you need at the Office of Civil Rights website to help you get up to speed and to be compliant. All right, on to astroturfing, and this is I guess we could call it a term of art. This means, at least in my mind, how people use it is putting up false reviews on different sites. And the gentleman whose photograph is on this slide is Eric Snyderman, who is the current New York Attorney General. And Attorney General Snyderman really has taken issue with folks putting up false reviews and has turned his office loose on this very topic. And many medical facilities have been charged with putting up false reviews in New York. And just recently, there was a spa, and I'm just going to give you one example of something that's happened just in the last, I think, 30 days or so. There was a spa in New York that did some skin treatment and so forth, and they had contracted with a Canadian firm to get reviews, positive reviews on Yelp, and there's actual email correspondence that came out where the Canadian firm is saying, hey, look, it's hard. Yelp's got ways to figure out who are real patients, real consumers, and who are these false reviews. So we can't get all of our false reviews to stick for you, but we can get about 1 in 3, and we're hoping to get you about 40, 45 positive Yelp reviews we'll manufacture for you and get them to stick on there. And it's going to cost you in the neighborhood of $1,000. So this comes out, and it's the spa that gets cracked. Fine for that in New York, $50,000. So this is not something to play with, and I know people think that there's great anonymity on the web, and there can be, but not if the Attorney General wants to find out who you are and what is going on. There is, in fact, nowhere to hide in the digital age when these things are going on. So be very, very careful, and how much of this is medical practices doing it and how much of it is being done in the background by marketing firms on their behalf without them knowing, I can't tell you, but it is an issue, and you want to be careful if you're engaging folks that they are actually getting you real reviews and not fictitious reviews that you're paying for. It could have problems with the state attorney general, and we could also imagine licensing boards. So again, an awareness issue, and don't get caught in that net. All right, some folks are interested in doing some telemedicine or remote consultations, and this has become a real hot topic in the legal medical legal world right now. What needs to be done? How do we set this up? First thing you need to know is if you are practicing medicine, it is the location of the patient that you need to be licensed in, not the location where you are. So, for example, I am, let's say I am Mike Sacopulos, patient in Terre Haute, Indiana, and I consult with a facial plastics folks in Texas. If they want to treat or give a diagnosis of me remotely, start a physician-patient relationship, they would need to have a license in Indiana because I'm the patient and I am out of state. That also means that they would need to have insurance that would follow that. So in the telemedicine world, we have to be careful that we have license and insurance where we reach and where we treat patients. And this is always an issue and always a concern, but clearly something that can be addressed. There are lots of rules and regulations that have been brought forth by the Federation of State Medical Boards in the last couple of years on appropriate uses of telemedicine. And anytime, ladies and gentlemen, the Federation of State Medical Boards speaks, we should all stop what we're doing, put down our smartphones, turn our head, and give them a full attention, because these are the folks that are setting the standards by which your medical board will discipline physicians in your state, right? So this is what they're saying is of interest and where people can cross ethical lines, and this is really the organization that is the think tank on this, and all of your board of medicine that has licensed you is a member of this group, I will tell you that. And so we need to give them a great concern. Now, what they publish is all freely available online. The document on telemedicine is not terribly long. It's 8 or 10 pages. It's freely available. So if you're moving into doing consults, I think it is worth your time to pull this document up and review it. It's going to give you some ideas on when you move from giving educational information into when you actually cross the line and begin to practice medicine. The legal definition between the two is very important. And if you are practicing medicine, what type of things you need to do to match up. And so some of them are going to be obvious. And you need to have an informed consent policy for your patient and the telemedicine, and these kind of things that you would envision being in the informed consent are fairly obvious. The practice's name and the patient's name, all of these. But there are some less obvious ones that are spelled out here, and that's why I'm encouraging you to review. And that is things like you need to have a hold harmless clause if there is a technical failure during the telemedicine proceedings or interaction with the patient. So there are these kind of unique little twists or oddball situations that they have spelled out. And again, it's freely available anytime you want to take a look, and they are definitely the authority. But they're not the only authority. And this just in, ladies and gentlemen, the American Medical Association has issued ethical guidelines for the practicing medicine, telemedicine, right? And this is just within the last several months that they've issued these, and there is good overlap with the Federation of Medical Boards rules, but they're not identical. And so again, this is freely available, and I think it's a shorter document, just a couple of pages. It is definitely worth reviewing if you think you're going to get into this space and do any kind of remote consults or telemedicine. I think that telemedicine is going to be a bigger and bigger issue as we move forward. Those that for getting reimbursement from third-party payers, I think we're starting to see some motion in that direction. Traditionally, that's what's been holding this field back, is that you couldn't get paid for your telemedicine visits unless they fell in some unique category of rural medicine and so forth. Note that each state has its own requirements, and some states require that you can only practice telemedicine with an existing patient. They have been physically in your practice, to your office, before the telemedicine interaction. Other states say that's not required, but we do require that there is no compromise in the health care by the use of telemedicine. That it would be essentially the same as if they were physically present in your office. And certain areas of medicine lend themselves better to this than others. You can imagine that this might fit well with the dermatology practice, but maybe not so well for an endocrinologist. So again, we will see more of this, but there's plenty of info out there if you want to head down this path. And I think we will see more and more people going down the path. So, and it certainly can be done in a safe way. All right. Let's hit another popular topic that I get lots of questions on, and that has to do with ransomware. And this is really just within the last a number of months over the summer, late spring and summer. We saw a number of ransomware attacks on hospitals on both coasts and medical practices. And I guess first what I should do is take a step back and tell you what ransomware is. And this is some nasty program that gets onto your computer and locks up your medical records. It effectively encrypts your patient's information. Your electronic medical records become encrypted, and you don't have the key to review them. Then you get an email that says, we'll give you the password or we'll give you the key to get to your own information, but you must pay us. Right? That's the ransom. They're holding your medical records or your patient's medical records hostage for money, so then access to them. You have to pay up. Well, are there ways to crack this? Well, it's relatively tough to get through, and there are programs out there that have become pretty popular. CryptoLocker is one of them that these ransomware firms are using, and what they usually do is they send out emails, and somebody clicks on a link, thinking it's a legitimate link, and that actually launches this malware onto their system, and it encrypts their whole system, and they can't get any records. So what do we do about this? Well, the easiest solution to dealing with ransomware is to have your system backed up frequently. So if the records are encrypted, you've got a backup that is not encrypted or not corrupted by this malware. All right, but let's say that doesn't happen. There are a number of people that will advise you to pay up the money to get access because it is far less expensive than trying to go through the process of getting to the records. Meanwhile, obviously, your patients need access for quality of care to their medical records. This is a big problem, right? Because the Office of Civil Rights also says any kind of ransomware attack, even if you have backup and you can reinstall and you don't pay the money, it's still considered legally a breach, and you have to notify people that their records have been compromised, and that can be embarrassing and expensive. So you need to know that. The other thing that you need to know about ransomware is that even if you pay and you get the key or the password to your own records, they don't come back in good shape. So much of the cost associated with ransomware is trying to reconfigure your own information after the fact. So it is pretty much across the board a disaster if this happens, and the experience of my clients has been disastrous. Even with backups, it's still problematic. So your best defense on this is training staff up front. And I think as a profession, medical profession, I'm sorry to say, does a relatively poor job at cyber hygiene, and certainly training folks about bad practices. I go in office after office. I see passwords taped to monitors. I see some that don't use passwords at all. The vast majority of the practices I'm in, the staff has never been taught about phishing emails or spear phishing emails, and all of this is an awareness campaign. It doesn't require huge amounts of education, but it does require some, and it is, in my mind, about the best money that you can spend. This is a legitimate threat. The FBI is out there warning medical practices all the time about ransomware, and you can see up to 130% in one quarter. So take this seriously. This is a major cyber threat to your practice. Well, what is it? This gets down to the brass tacks, as my father would say. What does this cost us? Well, cyber events, whether you're hacked into or have malware or ransomware installed on you, are expensive, and there are a number of companies out there that try to do surveys, and the insurance industry tries to do this as well. And the best we can tell is it's anywhere from about $180 per patient chart to about $260 per patient chart to respond to a malware or hacking or cyber incident, right? And this would be not only having the forensic folks come in and figure out what's happened, but also posting notices and mailing out notices to patients and all the things that go along with a breach response under HIPAA. So it's expensive. And if you think about how many patients you have in an electronic medical record and then start to multiply by $200 a head, you can see that it is an enormous number. So what do we do about that? Well, I encourage you to enter the world of cyber liability coverage. I think you need a cyber insurance policy. And this is certainly something that in my own family with my wife's practice we've purchased. I don't sell insurance. This is not to try to get you to buy anything from me. I couldn't sell it if I wanted to. Contact your own brokers about this. But this is an area that can be extraordinarily costly for practices, and the vast majority of practices do not have any coverage or certainly do not have appropriate coverage. So I warn you, check it out. Sometimes your professional liability carriers say that you have cyber coverage, but it is in such a low dollar amount as to not really be significant. That's the bad news. The good news is right now premiums for this type of coverage are relatively low, especially when compared to normal medical malpractice coverage. So it shouldn't be horrifically expensive to purchase this coverage. And I think it would be money well spent. We could go through the boxes if we had a little bit more time about what's first-party coverage and what's third-party coverage. First party is yourself. Third party would be related to others, your patients, and so forth. It's something to ask your broker about. And cyber policies are not uniform, so you need to have somebody who's a good broker that can help you learn the differences, because it's not apples to apples when looking at different companies in cyber coverage. But it is something that's worth spending the time and money on, in my opinion. Okay. With that, I'm going to take a deep breath and look for questions. And Chad, I see that I have a couple of questions here, and I don't know if you have any at your end that you would like to start with, or if I should just delve into the ones that your audience members have posted.
Perfect. First of all, Mike, thank you very much. And everyone, you see Mike's information there. If you've got questions, please feel free to reach out to him. One of the first questions we do have here, Mike, is a question of whether or not is Skype for Business HIPAA compliant? And there's others out there similar to that, FaceTime, I get asked that sometimes. So are those types of services HIPAA compliant? I think that's a great question.
It is a great question. It's one that comes up with some regularity, and all of these are slightly different, and they should be able to tell you, but generally they are not HIPAA compliant in that the transmissions from location to location are not fully encrypted to NIST standards, National Institute for Standards and Technology, which is under the HITECH Act, the standards that we need. But so what do? Well, the answer is that patients can agree to have transmissions that are not secure at all, and most patients feel completely comfortable saying that they're going to do something under FaceTime or Skype Business. So I think it is just a matter of getting the issue out there and saying, hey, this is not a perfectly secured transmission. Are you okay with that? And if the patient agrees, you're free to go. You're all set. So that would be my recommendation.
Perfect. I've got a couple other questions here for you, Mike. You talked about the cyber liability insurance and that most don't have enough, and obviously you don't sell it, but you talked about having the right amount. Do you have a range of how much cyber liability coverage they should have for their practice?
Sure. So, and again, another really good practical question of if we're buying it, how much do we buy? And I think that depends upon the size of your practice and whether or not you keep how much information is kept electronically. And I know we're all more and more dependent upon electronic medical records. And if we think about that number of in the $200 range per patient, if our system was hacked, what could be our upper limit exposure? And I'm not suggesting that you have to buy it so every patient would be $200 times every patient, but I think that gives you the high end exposure on cyber liability. And for most folks, it is I'm seeing policies being purchased for smaller practices, 2-3 provider practices in the $1 million category. Professional liability insurance is bundling in $25,000 or $50,000 worth of coverage into most policies, and that's why I'm saying I think $25,000 or $50,000 is not enough. Look to take it to the $1 million level for a smaller practice.
Perfect. Great. I know there's a couple other questions that were brought up. Do you want to address a couple of those?
Yeah, absolutely. So one of them that was here and is a little bit outside the scope of what we talked about, but I think it's a great issue and certainly related is, can I stop employees from posting comments about my practice on social media? And you know, that unfortunately happens, right? Sometimes people get disgruntled. Even the happiest employee has a bad day and goes and vents on Facebook or some other social media platform. And so the answer is, it's a little tough. And it's kind of the typical attorney answer is, it depends, and maybe it does. What you need to do is to have a social media policy that sets forth some guidelines. Certainly it's fair game to say you can't post anything about patients, because that compromises confidentiality and violates HIPAA, and you're safe there. The worry is that you're telling people that they can't post information about their actual employment conditions, which the Labor Relations Board takes issue with. So it's a little bit of a fine line, but there are folks out there that can help you with having a social media policy that gets you to where you need to be. And there are also some large entities that have their social media policy posted, and you can take a look at those just to get some ideas. And by that I mean, you know, large hospital systems where you can go on and look at there. So I think it is worth noting, and it's sad that sometimes we have these kind of problems out there, but it certainly does happen. The other question that someone posted, and this is a little bit more of a technical HIPAA question, is, do I need a BAA, which stands for Business Associate Agreement, with my marketing firm? And this is a good technical HIPAA question. And generally, yes, anyone that is working with patient information, and patient information can even be email addresses. It's any way information can identify a person. So certainly an email address of your patient constitutes protected health information under the law. And if you're having someone work with that, they need to sign a business associate agreement. So the answer to that question is yes.
Yeah, perfect. We have another question that just came in. Mike says, sometimes patients would request for an RX to be emailed to them. As protocol, we advise patients that due to HIPAA, we do not recommend it, although patients still insist. What's your take on this?
Well, I think whoever sent that question is right on point. That's right. It's outside the scope of HIPAA because it is not it's not encrypted. They could send it encrypted, but they can also rely and follow the patient's wishes. And so if the patient has asked for an RX to be emailed and knows that it's unencrypted, that's perfectly fine and legal because you're getting the patient's permission. It's just the practice can't initiate that and fire off RXs without the unencrypted without the patient's permission. So you're headed down the right path. I will also tell you that the vast majority of patients, in fact, I've yet to meet one who really wants an encrypted email. They all think that it's a total pain and a hassle to go through, and they're happy to waive off their right to encrypted email. They will do it gladly. So it's maybe not quite the obstacle that a lot of people think.
Very good to know. Another question for you is with reviews. You know, certainly we talked about you cannot do the fake reviews, and nobody ever should. You know, it's a really bad practice to start with. But I get asked all the time, somebody's left me a bad review online. How can I respond to that? And I talk to them about the importance of, if they know who it is, to call that person privately, kind of throw their ego out the window, see what they can do to make it right, see what's going on, and if possible. But if that person's not responsive and that comment's out there, sometimes, I know offices want to just go and say, acknowledge it, thank you for doing this, we've addressed it, we'd love to see you. What restrictions do they have of actually doing that? Because, the worry is now you're acknowledging that it is a patient, or did the person waive that when they actually put that review?
Good question. In Chad, I got to say, I completely agree with your reach out to the person if you know who it is. Unfortunately, you're right. Sometimes we just don't know who's posted an unhappy review. I think that the best you can do in a lot of situations is to try to say, we're sorry that you've had a less than favorable experience, and would like to discuss that with you to try to make things right. In some kind of a generic post, I know that there is a school of thought that you're really acknowledging that there is a problem, but I think that the downside to that is not as great as the downside of looking like you just don't care. And you're just not responsive, and people can post whatever they want, and to hell with them. I think that that's the wrong message to send, and you're right. Check your ego. If you know who the people are, reach out to them. If you don't, you want to post something that is doesn't get into, well, you know, you must have been off your meds when you posted this, or some other kind of crazy thing. And believe me, I've seen such things, and you think, oh, I can't back up far enough to help these people. So,
is there danger responding to that, of acknowledging that they are a patient?
Well, I think that you have to take them at their face value. If you don't know who it is, I don't know if there's a danger to saying, to acknowledging that they're a patient or not. It's a tough position to not know why someone's upset with you, but I think you want to try to offer the olive branch and to look like you really are concerned and want everybody to have a good experience, and that will go a long way. Occasionally you'll get somebody that will post a second hostile email, and that's okay too, because they start to paint themselves as kind of a crazy when they do that, in my mind, you know, that you're trying to be solicitous and want to have a conversation, and they're just a ranting person, at which point I think that their previous posts get discounted in most folks' mind. There was a great study that was done by Cornell. It looked at reviews, and what they were saying is that if somebody had all perfect reviews, the general public didn't really believe much in it and thought it must be rigged or contrived, and that perversely an off-color or a non-favorable review every once in a while gave a whole lot more credibility to all the other real positive reviews. So this is, you know, trying to put a happy spin on if you get a not so nice review. Maybe it's really legitimizing all the others, according to the Cornell study. So yeah, I know it doesn't make it feel much better. It doesn't make it feel much better when you read it, though. So,
you know, Mike, another question that came up is on this section 1557, which you're right. I mean, you're kind of the messenger, but I've had actually a lot of our clients reaching out to us over the past several weeks as they're attending various conferences. They're getting hit upside the head from their medical societies, making them very aware of this. So, you know, the medical societies are looking out, you know, for their members as well, and making sure they have this. Can the information that needs to be part of to make them compliant online with Section 1557, can that be included in the general terms and use?
Well, there are two things. In no, I don't think that it can be. It needs to be in such a form that someone can see it with the other types of things like privacy policies and so forth. So I don't think that it would be compliant to put it in a long list of terms and use. That's the bad news. Now, we should also take a moment to pause, because Section 1557 may not apply to a lot of practices, and here's why. If you are if you are just doing cash pay, you're outside of this. For those of you that are accepting Medicare Part B, which is what is most physician offices, that's also excluded. But Medicaid patients fall within this. So if you accept Medicaid, you're back into Section 1557. If you just accept Medicare patients at a physician's office, that's Part B, and you are excluded from having to comply with 1557. So many of your practices out there may not have to worry about this. But certainly hospitals, they're all Part A, and they fall in this. So you're going to see a lot of people complying, but maybe you don't have to.
Yeah, very good to know. Did you have another question that was on your list there that came over?
I had one more here that came up, and that is, are cloud-based EHR systems okay/safe to use? And I think that my general response to this is yes, that there are a number of EHR providers out there that are cloud-based, and they are generally very secure and kept up, and oftentimes as good or better than having servers in practices that have to be maintained by outside IT folks. But yes, they can be. You want to make sure that your folks at your EHR company are HIPAA compliant, and to my knowledge, everybody who's in this space is well aware of the issue, and you're probably safe. But let's ask the question, because there are plenty of people out there, and I can't vouch for every last one of them. But yes, generally you're okay on a cloud-based EHR platform.
Perfect. Mike, one last question today is in regards to social media, and I know this is one that is just a hot topic. But question is it okay for me as a doctor, for my staff, to take pictures with patients and post them online? And the second part of that is, do we need a new release every time, or can you have one that, you know, from the first time they signed up or came in for photos?
Okay, so great question, and this kind of gets at the issue about whether it is a medical photograph or if it is more of a social type of situation. Because I know a lot of practices have host events where patients can bring in others and they can have some education and a fun evening or something, and photographs are taken there. That would be different than a before and after of, say, a rhinoplasty or something. So generally, if you're posting a photograph, you need to have a release, one way or the other, whether it's medical or if it's in the normal kind of newspaper category of a general photograph. Yes, you can get a release that will cover photographs taken in social settings, meaning not a medical photograph, kind of prospectively going forward, and encompass a number of different photographs. For the individual medical photographs, where it's actually documenting some kind of medical condition or a medical treatment, then you would need to have releases signed at the time the photographs were taken. And I don't think that we could use a release from a prior procedure 6 months ago to carry over for the new procedure.
Yeah, I've heard that as well, that it really, each time you take photos, even if is on the medical side with a new before and after photo, you should get a new release each and every time for that.
I think so. I think that's the safest, right? Because the patients have the ability to consent or not to photographs being used in certain situations. And the argument's going to be it's real hard to consent to photographs that haven't been taken and won't be taken for another 90 days, right? Because who knows, right?
Right.
What those are going to look like, and how can I consent to something that doesn't exist and won't exist for months on end?
Yeah.
So that's why I think you need to do it in a medical setting as you go. As much of a pain as that is, I think that's a proper legal answer for you.
Perfect. Well, Mike, thank you very, very much for your time today. Appreciate all of our guests for attending and for your questions today.
Well, Chad, thank you, and thank you very much to Advice Media, who's an excellent firm, and I am grateful for the opportunity to present today. Thank you so much.
Yeah, it's our pleasure. Just a quick announcement to our attendees. Next month, December 7th, will be our next webinar. We'll be hosting Ava Shea, who's the Director of Practice Development from RealSelf, and she'll be talking about how you can really enhance your RealSelf profile to attract new patients. RealSelf can be a great way for really getting you new patients. I've known Ava for about 10 years now, and so we look forward to bringing that to our guests next month. Mike, thanks again.
She's great. She's great. Everybody should listen on that one. She is great. That'll be a good webinar.
Thank you. Mike, thank you very much. Wish everybody a happy Thanksgiving, wonderful November. It's crazy to think we are in November, people. So anyway, enjoy, and I look forward to seeing you next month. Bye-bye.